And I would now invite our next
Thank you.
presenters to please come forward. Mr. Beamish, the Office of Information and Privacy Commissioner of Ontario. Mr. Beamish, I think you are well aware of the drill here.
I am. Thank you very much.
Begin now.
Thank you. Good afternoon. And Mr. Chair, members of the committee, thank you for the opportunity to speak to you today. I am here primarily to express my support to the amendments in Bill 119 to the Personal Health Information Protection Act, PHIPA, Schedule 1 of the bill. It was developed in close consultation with my office. My staff worked very hard on this, and we're satisfied that it presents a necessary framework to support a shared provincial electronic health network, a health record in the province. We have 3 amendments. One is a minor amendment to Schedule 1. The other 2 relate to the Schedule 2, QCIPA. You have that along with agreed wording. Rather than use my time to explain why I support the bill, I thought my time might be better spent to address some of the issues that have been brought to your attention today and to give you my comments on it. The first one relates to our first recommended amendment to QCIPA and involves the role of my office, the Information and Privacy Commission, in the quality of care discussion. I should underline that we do not have oversight over QCIPA. If you read QCIPA, you will see no mention of the Information and Privacy Commission. We do get involved in the issue of particular information, quality of care information. And let me give you a scenario to explain that. A typical scenario, an individual dies in hospital. Their family, quite understandably, would like to get information about the death, about the care provided, the circumstances of the death. They have the ability to put in an access to information request under PHIPA, the Freedom of Information or Protection of Privacy Act, or under PHIPA. That's not a request put in under QCIPA. It's put in under PHIPA or PHIPA. The hospital has to respond to that and hopefully provide records and information, but they may deny access to some information on the basis that it's quality of care information, and there is a prohibition on the hospital of disclosing that information. That family then has a right to come to my office and file an appeal under PHIPA or PHIPA. And we have a tribunal process that will determine whether they have received access to the information that they have a right to. That may involve us analyzing whether the records withheld by the hospital really have been properly characterized as quality of care information. In order to do that, our experience is we need to see the records. It's impossible for us to provide a sound decision on whether particular records have properly been categorized and labeled as quality of care unless we see them. As the QCIPA is currently worded and as Schedule 2 is currently worded, the hospital would be in a position to say to us, we cannot disclose those records to you. There is a prohibition on disclosing QCIPA records. There are exceptions to that, but one of those exceptions is not providing that information to the Information and Privacy Commission. So our main recommendation to you is to clarify in QCIPA or in the legislation that hospitals are able to provide quality of care information to us so that we can perform our duties and functions under PHIPA and PHIPA. Now I know that this morning there was some discussion about this, and I think the Ontario Hospital Association indicated that we would be bringing this forward. I don't want to misspeak or mischaracterize the comments that were made, but I thought I heard the suggestion that our processes at the IPC were too informal to be entrusted with the decisions around quality of care, and I really would like to dispel that notion. We manage or handle over 1,400 Freedom of Information requests in the course of a year. We handle requests of patients for their information under PHIPA. Our process is not informal. All of those requests and appeals to our office would go through mediation. We have trained mediators, professional mediators. They're guided by the law. They're not acting in they perform their duties professionally. If something isn't mediated, it goes to an adjudicator, and we have very strict rules on how adjudicators handle information and handle appeals. We have rigor to the process. They provide the parties with an opportunity to present their case, and then they follow the law in making a decision. So I would like to dispel the notion that we somehow cannot handle this. And I would also note that this is a much easier process than requiring an individual to go to the courts. The family in the example I gave you does not have to be represented when they come to us. They don't need a lawyer, and we'll give them a quicker and cheaper answer than rather than requiring them to go to the courts. The other comment on this issue that I thought I heard was that quality of care information is of a quality and of a sensitivity that somehow wouldn't be proper or safe to entrust it to our tribunal. And again, I'd like to really dispel that notion. We handle, as the nature of our job, we handle sensitive information. We handle personal health information. We handle sensitive law enforcement information. We handle cabinet records. We handle records related to national security. So we're fully aware of our responsibility to ensure the security and safety of records that are given to us. Let me move on to another issue that has been raised a couple of times, and that is around breach reporting. You'll know that currently there is no requirement in PHIPA to report breaches to my office. It does happen. Custodians do come to us to self-report, but that's discretionary. They have no obligation to do that. So we're fully supportive of a breach notification being built into the law. You will know, though, that the breach notification will be subject to parameters that are put in place by regulation. And we're fully supportive of that as well. We understand that there is a spectrum of breaches in terms of seriousness. We don't want to put a burden on custodians to have to report every breach, nor do we want to handle every breach, the trivial breaches. So we're confident that, and we've already worked on what kind of criteria would go into a regulation to set the parameters on when our breaches should be reported to us. Those parameters could be put in legislation. I wouldn't have any objection to that. I think my preference, though, is to leave the bill the way it is and have that description left to regulation. I think that provides more flexibility. If we don't get it right in terms of what the threshold is for reporting, it strikes me that it's easier to adjust the threshold if it's in regulation rather than having to introduce another bill to change that. There's also some discussion around reporting to colleges and the sense that any reporting under PHIPA to regulatory colleges should mirror the reporting that's currently in place. And I guess my view on that is when I look at the current reporting that's required to colleges, it looks to me like a pretty high threshold. It does talk about professional misconduct. And I think if we were to have PHIPA mirror that, we would be relying on custodians to interpret breaches of PHIPA as professional misconduct. And I can tell you that from our experience, it's not uncommon for us to deal with a healthcare organization like a hospital who may have found that a staff member was engaged in unauthorized access or snooping. It has terminated the employment of that individual, and when we ask, have you reported to the regulatory college, the answer is no. So that tells me that there is a disconnect between what their view of professional misconduct is and breaches to the Act. So I think that my recommendation would be to leave the legislation as it is, and if an individual is subject to discipline for a breach of the Act, that there's a duty to report to the college. I'll leave it at that and take your questions.
Thank you very much, Mr. Beamish. We pass to the PC side. Mr. Urick.
Thank you again, Chair. Thank you for coming out, Mr. Beamish. Appreciate your comments. and your suggestions, and we'll take a good close look at them. As Privacy Commissioner, do you have comment on what the OMA had brought forward, the fact that personal identifiers will be linked and allow the government to access? What's your view on that aspect?
Well, I do, and I think it's a mischaracterization to suggest that the result of PHIPA will be a database of identifiable patient information that's available to bureaucrats. And I can tell you that if that was the result of it, my comments here to you today would be entirely different. Okay. The Act does allow for the ministry to collect personally identifiable information, but there are some pretty strict safeguards placed on that. It has to be collected by a designated unit. The activities of the ministry and the unit, the policies and procedures of that have to be approved by my office, and that unit must immediately de-identify the information. And the whole process, I'm confident that our office has the kinds of oversight we need to ensure that the scenario you heard described by the OMA will not come to fruition. I think we recognize that the ministry has a legitimate need to get information for planning, for funding, for detecting fraud. We recognize that. But there are safeguards in the bill to ensure that that's done in a responsible way, that our office has oversight of that process, and that you aren't creating a massive database of personally identifiable information.
So you can confidently 100% guarantee that none of that data would be used? I
guarantee nothing 100%. So
okay. That's a concern we raised, that data is now will be available and accessible, and I totally respect your office and your abilities, but that human nature is human nature at the end of the day. So that's a concern on our part going forward. We'll take a look at. But again, thank you for your presentation.
Okay, thank you.
Thank you, Mr. Yurt. Ms. Gillian?
I know that you spend a lot of time on this, and I appreciate your office work to bring us to where we are. How confident are you that if we vote for this, and let's say your recommendations don't go through, but we vote for the bill, how confident are you that if Mr. Ford was to go into the hospital and 200 people access his record, that there would be consequences?
I guess what I would say is I'm pretty confident that if someone like Mr. Ford goes back in the hospital, inevitably somebody's going to look. I think our experience is that despite all the training, despite all the policies, despite people being disciplined and reported to colleges, inevitably it happens. I think this bill, though, gives more tools to send a message that it's not okay. For example, the lifting the limitation period for prosecutions. I was listening to the conversation earlier this afternoon. The likely scenario is not that someone's going to be found having snooped 8 years ago. Our experience is what happens is someone is found to have done it now. And when an audit is done of their access to the system, there can be a trail going back years that they have been engaged in this kind of activity. The 6-month limitation period means that anything beyond the 6 month cannot be used for prosecution purposes. And in my view, that trail of activity should be something that is brought to the attention of a judge to indicate a pattern of behavior. So I think that's an important piece of this. I think also the doubling the fines, although it's unlikely that someone's going to get a $100,000 fine for this kind of action, but it sends a signal. It says this is serious activity, you shouldn't be engaged in it, and if you do, there will be consequences. I think the important piece of this is people know that they will be detected, and if they're detected, there will be serious consequences.
And if we look at the other piece, how confident are you that people, families who are trying to gain closure will actually have more valid information to gain closure?
I would say that with the amendment we've proposed, I'm confident that people will get the information that the law allows them to get.
That's if your amendment goes through?
If my amendment is not accepted, I would not be confident of that, because in effect, people would be left in a position of having to take the hospital's word that it's quality of care information.
Thank you, Ms. Jelena. Pass now to the government side to Mr. Anderson. Go ahead.
Thank you, Mr. Beamish, for your presentation here today. I know that the IPC was heavily engaged in this process throughout the development of the legislation, and I would like to thank you for your time and commitment that you have taken to do this. As you know, Bill 119 creates an advisory committee to make recommendations to the minister and privacy matters in the future. What do you think about the establishment of the advisory committee? I know you're here and you heard the OMA's position on it, so could you elaborate? Take as much time to
I think the creation of an advisory committee is admirable. I guess the question is then who populates the advisory committee? And the bill is silent to that. I suppose we'll have to wait and see who the ministry determines who should be part of that committee. I'm assuming they will have a wide range of stakeholders from the healthcare community and the community at large. That would make sense to me.
Okay. You alluded to the fact that the 6 months limitation has been removed, and that does help your office to have stricter controls over the privacy matters. And please expand on how that would help.
Well, the law currently allows for prosecution of individuals for willful violation of the Act, but the charges have to be brought within 6 months of the violation. The typical snooping case, as I mentioned, either there's a pattern that goes beyond 6 months, and that those instances cannot be part of the charges, which may limit the advisability of a charge, or the ability to prove willfulness, or the unauthorized access initially occurs outside of the 6 month period. So our view is that lifting the limitation period will allow greater scope for prosecutions. And I'm not talking about prosecutions in every case. I'm talking about prosecutions where there's true willfulness, the very, very serious cases. And I think that can send a signal to the community that this is serious behavior to be engaged in. I do think lifting the limitation period will really assist on that. And I mean, I've heard the suggestion it should be 2 years, it should be 5 years. I suppose at some point you're picking a number. My preference would be not to have one and leave it at that.
Do I have more time?
13 seconds.
Okay. I know earlier you alluded to the fact that you couldn't guarantee absolutes, that there couldn't be breaches down the road to private records.
Thank you, Mr. Anderson, and
Spare
thanks
the-
to you,
spare the answer.
Mr. Beamish, for your deputation.